SJC-12471, Committee for Public Counsel Services and others, v. Attorney General and others.
Ms. Jacobstein, good morning.
Good morning, Your Honors. Rebecca Jacobstein for CPCS. I will be addressing today whether the dismissal of all Amherst lab cases is warranted by Ferrick's misconduct, the Attorney General's Office's misconduct, including its inadequate investigations. Attorney Siegel will address why 2 additional remedies, standing orders and sanctions, are warranted by the misconduct of Assistant Attorney Generals Foster and Kazmarek, the Attorney General's Office, and the District Attorney's Office.
Can we get into Judge Carey's findings?
Sure.
On finding number 8 and finding number 9, he says that some of the drug samples tested, that Ms. Farrak tampered with some of the other drug samples. There's 7 that she calls names in her grand jury testimony. But he says also in finding number 9, the results are still reliable despite this. So he then defines, as you well know, what a Farrak defendant is based upon that finding. Is that a mixed finding of fact in law that we have to owe some deference to go beyond?
Well, I don't think this court has to do any deference because we're not technically on direct appeal.
Well, but he heard the facts.
He did.
And you certainly like the facts as far as what he found as far as misconduct goes.
Well, I guess here's the difference for Ms. Farrak, which is that he did not hear the facts. He took the documents that we provided to him and drew conclusions based on them because Ms. Farrak did not testify. So, but I think what Your Honor's concerned about, which is we are arguing for a conclusive presumption of misconduct for all Amherst lab cases. The Commonwealth, through the Attorney General's Office, is saying, no, draw the line in June 2012. So the question for this court is, where should we draw this line? The DAs are saying, no, not at all.
Right.
But I think that...
And are you saying back to when she was employed in 2004?
I'm only arguing Amherst today.
Okay.
So and she was employed in Amherst starting in August of 2004. But
so when you say you're only arguing Amherst, you're saying since 2004?
Correct. That is all I'm arguing today. But so if we do a big picture look at the evidence, it is undisputed that she tampered with other chemist samples, and it's undisputed that she tampered with unassigned samples, and it's undisputed that she manipulated the lab's inventory system. So the reason that the Attorney General's Office says you should draw the line in June 2012, and the reason that the District Attorney's Office says you should just be okay with this fact is based on Farrick's testimony or her proffer. She said June 2012 in her statement to the court. Under oath at the grand jury, the time is undefined. But I think the problem here is that Sonia Farrick is an unreliable and inaccurate source. And when she's given the opportunity, or when we have been able to check, she has been wrong about what she's done when. She said on January 9th, 2012, I was so high on LSD I couldn't function, but don't worry, I didn't do any testing. But if you look at the data, she did do testing that date. She ran the GCMS, she signed drug certificates. She said, I tampered with these very specific samples from this town of these weights. Those samples don't exist.
The U.S. Postal Service case that she mentions.
That case does exist from 2009. There is a U.S. Postal Service case in 2009. Absolutely.
So let's just take a look at everything as far as the way we could look at these facts, and assume for the purposes of my question that there's an issue about whether Ms. Farrak was touching samples and impacting drug testing before June of 2012. We can't rely on Ms. Farrak. She's, as you said, high on drugs. We've got the coworkers' observations, but those, we can't be precise of when those observations mean is when she started using drugs. We have her admitting that she used samples. So assume, for the purpose of my question, that there is some evidence of pre-2012, June 2012 tampering. Why don't we have a situation where those are Bridgeton 2 cases?
The reason we don't have, this isn't Bridgman 2 at this point.
With the pre-2012 and Farag did not do the cert.
Because at this point, we're too far gone. It's been 5.5 years since this scandal broke. And the investigation to this point is still inadequate into what she did. Certainly, that's the first problem. But the second problem is we are 5.5 years out because we were delayed by the fact that 2 assistant attorney generals withheld exculpatory evidence and lied to the court. And so now we're asking our clients to come back and try to explain what they did 12 years ago, even more than that, and we're asking for a further delay while the Commonwealth goes through all these cases to figure out which bucket to put them in. And my clients shouldn't have to be burdened by this delay anymore.
Can I ask you, what was the role of the state police audit in Judge Carey's finding that, in his definition of a Farag defendant? He said that it was reliable results. What was the basis of his conclusions in 8 and 9, as you understand it?
The reliable results.
Yeah, the fact how he, as you alleged, narrowly defines who a Farag defendant is,
Yes.
right? He makes a particular find, and he says, despite what she did, there were good results that were reached by these other chemists, the other 3 chemists. As you understand it, what was the basis of that?
Well, I think the basis of that is twofold. I think we did challenge below how that lab was run because it was not run very well. And there were a lot of deficiencies in the way that lab was run. But I think what he found was based on the Commonwealth's expert. The Commonwealth's expert said, look, there are these deficiencies, but a good chemist, a chemist who's paying attention, can in fact note them. So he said, these 2 chemists over here, they were good chemists. They could figure out these. And this chemist over here, Farag, was not. She could not. So her case is she's a Farag defendant. To the extent that he said, and she only tampered with their samples after,
Right, I mean.
because she said so.
Okay, and that implies that she tampered with the samples, that they reached accurate results when they first tested them, but that doesn't speak to the ability to retest them by a defense expert or the integrity of the sample, correct?
Right, correct. And it also doesn't speak to the unassigned samples because she was going in and she was tampering with the unassigned samples, and then she claimed that she was getting all of those unassigned samples assigned to herself. But I don't think we can rely on that assessment either. I think that one thing Judge Carey did find is that some of what she said defied logic, and I think that that would fall under that.
I mean, it's a big step from 2012 to when she first started, right? And that's 2004.
That is a big step.
Okay. And so what I'm trying to get from you is the bad practices, she has unfettered access to everything. Drugs, computer system. And your position is because she's so unreliable, we can't take her grand jury minutes, and proven unreliable, we can't take her grand jury minutes to heart, so therefore, the whole lab, all of these samples
Yes,
are
and.
tainted.
So, yes, but also, we have the fact that there is a lack of evidence in this case, and this is from Codo. Any deficiencies in the evidence as to the timing and scope of Farag's misconduct are attributable to the Commonwealth in light of its failure to conduct a thorough investigation. So we're also saying, because we don't know, because we can't do that investigation, and that was on them, and they didn't do it. But I also think that this is comparable to where we were in the Hinton Lab scandal.
But isn't this different than Hinton, right? I mean, the judge emphasizes that Farag is stealing to use. So she's not creating, like Dukem was, false evidence to convict people, right? She's just stealing.
Well, she's not on purpose, certainly. But I think that.
So how do you end up with a false positive in that? I understand how the weight would always be wrong because she's stealing drugs. But how do you, given that she's using the drugs and if anything, putting back in she's putting in filler, essentially. I'm just trying to understand.
Right. What you're saying is where's the prejudice to people? And I
Well,
think,
and I'm also saying that we're trying to analyze, you want us to reverse all the convictions from 2004 to 2012, but she's a little different than Dukem because she's not trying to convict people. She's just trying to use the drugs.
I don't think her goals are what's relevant here. I think
Well, but
what's
Dukem-
relevant is.
But we're worried about whether she's creating with Dukem, we were worried about, she's trying to convict people who
Well, I think what Dukin was really trying to do was make herself an invaluable employee, and so the reason that when she went negative to positive, she did that because she got it wrong, and she wanted to cover her back. But I think
But
that
this person never goes, she has no incentive to create a positive that's not in existence, right?
she doesn't, but that doesn't mean that her actions haven't totally undermined the foundation of someone's case.
No, I understand that, but I'm just trying to understand how we get how we have false certifications besides the weight with her, where someone's, found to have cocaine, for example, when they don't, because she's just taking the cocaine out to use it. She's not, fabricating evidence.
I don't know that we do. But I would say that in Hinton, when this court decided which cases we're going to keep and which cases it was going to throw out, it didn't make a distinction between primary chemist, which is where she was able to try to change the negatives to positives, and secondary chemist, which is when she just falsified GCMS records and was not following protocol in getting the samples. So the fact is that it's not necessarily only the due process rights of the defendants which have been affected, but it's also the integrity of the criminal justice system, which has been wholly undermined. And I think that what this court has to do is when it says where are we drawing the line, it's saying we are reasonably certain on this side of the line that she has committed misconduct, and we're reasonably certain on this side of the line she hasn't. And I don't think we can be reasonably certain that she hadn't on any part of the line. And to the extent that we don't know, it's because the Attorney General's office didn't do an adequate investigation.
And we get here after this court heard Cotto, and in Cotto, it's kind of blind man's bluff. We don't know what's going on, and we refer it back to the Attorney General's office of the prosecutors to say, tell us what happened, essentially. After Cotto, can you walk me through how it is that the investigation fell short and what role the Attorney General's misconduct had in delaying the investigation?
Well, so the Attorney General's misconduct originally, back in 2013, delayed the investigation. Then this investigation was inadequate because they didn't do an independent assessment of its impact on the whole lab. What the AGO said, it says, the Attorney General's office has provided facts gleaned from its investigation without evaluation, without any determination about credibility, and without the drawing of any conclusions. That's not an investigation, that's a taking her at her word for it. And that's not enough here when it's incumbent upon them to do the investigation.
Is that up to Caldwell or including Caldwell?
Originally, there was no investigation.
Right.
So
I'm not
this is
saying,
only the
does it stop at
2015 Cotto report. They brought her in, they gave her immunity, they asked her questions, but there was no corroboration of what she said.
So your position is that the Caldwell investigation fell short as well?
Yes, that it was inadequate because it didn't independently determine or investigate what actually happened and where this line could reasonably be drawn.
Before you even get there, though, your position is that even before Kodo, at least the two assistant attorney generals knew what was in Farrak's car. You had the letter already being sent by Attorney Ryan to the Attorney General's office, and you've got the mental health records that were found in the car. That already existed. Am I wrong? Didn't that already exist before the hearing in Kodo?
Yes, I came to argue, and the Attorney General's office was aware that it had that information and did not inform this court.
So with regard to Ms. Dukin, we said any certificate that she touched, either as a primary or as a secondary chemist, yields the conclusive presumption of wrongdoing so as to protect a defendant from having to prove it. Here you're asking us to go well beyond anything that we have any reason to think that Ms. Farrak touched. And the principle as to why we should do that in the absence of evidence that she may have tainted it from any source is what?
I don't think we can say that we don't think she tampered with that stuff. I think in Dukin, she said, hey, I have only been doing this for 2 to 3 years, but this court went for the whole time because it didn't know, because it belied reconstruction. And that's where we are here, is we know she's tampered with other chemist samples. We don't know how long she was doing it, but it belies reconstruction because Farrak is unreliable and because the Attorney General's office didn't do an investigation.
And in this case, she also had unrestricted access to everything in the lab, is that
Everything.
correct? So including the computer system, including any safes, including
All the safes,
everything.
everything.
So I think the Attorney General's position, they'll correct me if I'm wrong, is that when you take cases where Farrak did not do the testing, but the cases between June of 2012 and January 2013, that those defendants should be Farrak defendants and the functional equivalent of Bridgman 2 and require certification. And for us to go beyond that, because as I mentioned earlier, we can't be assured that nothing happened earlier than June of 2012. I go back to, if we go earlier than that, this is picking up on Chief Justice Gantz's point, where's the doctrine? Because we don't really have cases, other than perhaps Commonwealth versus Manning, where we have presumed prejudice without actually showing it. So what's the doctrine to dismiss all the way back to her first day on the job in 2004? Is it a presumption of prejudice?
It is a presumption of prejudice.
So it's Commonwealth versus Manning, is that?
I mean, it's Manning, but I feel like it's once you get the fraud on the court cases and the prophylactic remedy cases, this is really your only result. I think the June 2012 line, well, of course, we appreciate any willingness to, in respect to the rights of more people, is still somewhat arbitrary because it still requires you to believe in Farrak. And so we presume prejudice because we know that there has been prejudice. And the doctrine that I was following was the one laid out in Scott, which is there's a reasonable certainty that her misconduct touched a great number of cases. That we know. We just don't know which ones they are. And that's the same for Dukin.
But how do we know that her misconduct has resulted in a false certification, right? I'm just trying to understand that, right? That's in order to exonerate someone on don't we want to find that someone else's certificate is inaccurate, right? It's not just that she went in and dug cocaine out of their sample, but she somehow got to suggest that it altered the result of the certification, right?
Well, I mean, like I said before, I don't think we can show that. But I think that weight is incredibly important. It gets you to mandatory minimums and
I
and a
think the
whole
weight,
host of.
I get you on the weight,
But
I see
mean,
that.
I concede that we don't have that. But that's, I think that is
So
not
then-
necessarily the
so then-
point.
So then what is the but then it gets back to the Chief's and Justice Lowy's question. What is the principle then? Just, it's
That we have a
because,
criminal justice system that people need to believe in, that needs to have integrity, and if we are going to say we are keeping this conviction and we are not keeping this conviction, we need to have a reason for that, and we don't have a reason to keep any of these convictions knowing they could have been tampered with.
Well, I mean, the June 2012 date is not arbitrary. It's viewing the evidence in the light most favorable to the defense. It is the only date on which there's any evidence that the taint was beyond Farrak's own testing. So if you were to look at the evidence in the light most favorable to the defense, relying at least on evidence, what would be the argument that there is any evidence viewed in the most favorable light to the defense that would suggest that we should go back beyond June of 2012?
We don't have evidence, right? She picked a date, that was the date she chose. Maybe it's right, it's probably not. We don't have a date. And we don't have an investigation, so we have no way of knowing.
And I guess the question then is, how can we make a finding beyond that which is viewing the evidence in the light most favorable to the defense?
I wouldn't say that that's the light most favorable to the defense. I think the light most favorable to the defense is she was tampering with other people's evidence. She was tampering with unassigned samples, and we don't know how long she was doing it, so we're just going to presume that she was doing it the whole time because we have no reason to believe she wasn't. And we don't have an investigation telling us. No one did retesting or went and just did a spot check of samples like they were originally going to do, but somehow got away from. It's just there's nothing. And to allow that to stand is to benefit the Commonwealth in saying, hey, if you don't look into this, you're protecting your convictions, no matter how unfair they are. And it may be that some of these were fair or most of them were fair. Not all of them were fair. We don't know which ones, but they shouldn't get the benefit of their unwillingness to do their duty to investigate.
Remind me the date of that Farrak's car is, so the
February
AG's,
19th, 2013.
okay, so the AG's misconduct doesn't,
2012.
2013.
so the AG's misconduct doesn't date before then, though, right?
No, until they got the evidence, they didn't commit any misconduct.
So then again, I understand post the AG's, you just made an argument based on the AG's misconduct, but that's post 2013, it's not 2004. The AG's not doing anything improper between 2004 and Farrak is,
No.
but no one else is.
No, but they're delaying relief for defendants. And
Aren't you arguing that the reason why the government doesn't get the benefit of Bridgman is because of that misconduct?
Yes.
And we were very careful in Bridgman, in all the Farrak cases, to say there was no prosecutorial misconduct, correct?
yes,
This is different.
very. Yeah, we have, and that's really the point, is that we have, Farrak's misconduct gets us the conclusive presumption, but it's the Attorney General's office's misconduct that gets us the dismissal, both as a prophylactic remedy and because of the delay. It's just been so long. There has been an added prejudice to our clients beyond Farrak's prejudice.
Okay, thank you.
Thank you, Your Honors.
Mr. Siegel, good morning.
Good morning, Mr. Chief Justice, and may it please the court. 2 additional measures are needed here because with thousands of wrongfully convicted people yet again before the court, the remedies for this scandal need to prevent the next one.
Let me ask you, Mr. Siegel, on the proposed remedies. I don't think there's a prosecutor, certainly in this room, or hopefully in the Commonwealth, that doesn't know they have Brady obligations. The question is whether they fulfill those Brady obligations is a different story. What's the benefit of a stand-in order like New York has issued in every case, which could, if it's routine, become like a mattress tag, versus a more robust rule of criminal procedure, which would be applicable to every case prosecuted in this Commonwealth? Why is there a difference between that, and why should we pick a stand-in order versus a rule of criminal procedure?
The virtue of a standing order, Your Honor, is that there is a capacity to impose clear reminders at the outset of a criminal case to a prosecutor about their obligation, clear deadlines, and clear consequence for missing those deadlines. One of the abiding lessons of both the Hinton scandal and this one is that there has really been no meaningful progress, that is, except when there has been litigation and court orders governing the process. The clearest example might be the fact that at the very same time that in the Bridgman litigation, district attorneys were undertaking a notice process, they were simultaneously not doing so in the scandal where they had not been sued. That was this one. In fact, the record before this court is that before 2017, only 2 out of the 11 district attorney's office has disclosed lists to this court. And in Essex County, which was one of the original respondents in Bridgman, the record before this court is that they did not begin a FERC list until 2017. So the virtue of the standing order is not necessarily that it creates new substantive law, it just gives it effect. And really, in this case, it would be holding prosecutors to the standard that they set for themselves when this scandal broke.
Well, the Attorney General agrees with you as it relates to protocols. What is it precisely that's inadequate? Not having deadlines and enforcement as a general matter? Or don't we need a case in order to figure out what deadlines and enforcement supply?
Well, the particular deadlines may be adjusted based on the facts of the particular case, and that goes back to Justice Gaziano's question about the virtue of the order, is that unlike a rule of criminal procedure, there would be some opportunity to adjust the deadline,
So
but they need to exist.
What's inadequate about the AG's proposal?
Well, there are a couple of things there. One is although I may be corrected in a moment, my understanding is it's thought of more of as an alert system, that there's an obligation to go to the court. That's one thing. And the second thing is, both in the AG's proposal and in at least one of the amicus briefs, there's a suggestion that there ought to be some threshold below which reporting in this process doesn't need to happen. And that's really dangerous, because if there's a threshold of a certain number or a systemic problem, then that actually creates incentive for the would-be reporter to underweigh how much misconduct has actually occurred, and that's what got us into this mess in the first instance. But to Your Honor's question about, how this differs maybe from substantive law, part of the point here is that it's not going to differ too much. And really, going back to the standard that the district attorney set for themselves, when this scandal broke in January 2013, they issued a press release that said there would be proactive, they would go in their databases, they would find the case, and they would be proactive in identifying cases and bringing them before the court. That just didn't happen. And what the standing orders that we have proposed, and which the Attorney General's office has agreed to, would do is make sure that it does happen. So far, I've been talking a bit about the district attorneys, but obviously want to go back to one of the reasons we're here and one of the reasons why these remedies are warranted, which is the sort of stunning factual record before the court. Chief Justice Gantz had a hypothetical in the prior argument about a holy cow moment. Well, this is a case that actually has a holy cow moment. It's now undisputed that Assistant Attorneys General Foster and Kaczmarek defrauded, in effect, thousands of defendants, including our clients, and misled a court. This holy cow moment occurred in November 2014, just a month before Cotto and Ware were argued to this court. Because at that moment, the supervisors at the Attorney General's office figured out that Chris Foster's submissions to the Superior Court contained inaccuracies. They understood that Chris Foster had withheld evidence that was directly contrary to the record before this court, and those supervisors did not tell the court. So one of the reasons why remedies like standing orders, remedies like sanctions, are so vital in this case is that this is a case where there has been wrongdoing by individuals, but there also has been serious missteps by institutions. And one of the virtues of these standing orders, one of the reasons for sanctions, is to hold those institutions accountable for making sure that this kind of misconduct doesn't occur, and for making sure that when it does, in the unfortunate instance that it does, it is mitigated. What happened instead is that after Foster and Kaczmarek poisoned the record in the Superior Court, that poison was permitted to spread, including to this court. I want to talk a little bit about the differences between some of the orders that we're proposing.
Before you get there, let's sort of speak in general. I mean, right now, the rules that we have come in two categories. We have the criminal rules of procedure, which set forth obligations with regard to discovery, including the obligation to disclose exculpatory evidence. And then we have the rules of professional responsibility, 3.7, which impose obligations on a prosecutor. Why should we not simply revisit those to see whether those are adequate as opposed to establishing a separate core of standing orders separate and apart from the usual rules that we have?
Well, the usual rules, Your Honor, don't really provide a protocol for addressing these situations. One of the things that came out of the Bridgman litigation was this prosecutor-focused model where instead of requiring defendants one by one to obtain attorneys and come before this court, prosecutors were held to their obligation, not just under the ethics rules, but under the rules of due process, under cases like NAPU versus Illinois, to affirmatively identify people. So that's part of the answer, is that we actually need protocols and not just the sort of ethical standard.
Isn't it that when a prosecutor receives exculpatory evidence, they just hand it over? What? Isn't it as simple as that?
It should be. And it's actually, it's worse than that in this case. I mean, there's a reason why the findings by Judge Carey.
But that's what I'm trying to get to, why, as I asked you the first and the Chief has asked you, why are our present rules of criminal procedure, which probably could be beefed up in our rules of professional conduct, why are those inadequate? Because I don't think in this case or cases we see, there are instances where prosecutors don't know they have a Brady obligation.
Well, it's going to sound like I'm trying to flatter you, but it's not the issue isn't that whether the precedent is inadequate or the rules of criminal procedure are inadequate. The issue is whether they've worked. And although the court is normally entitled to a presumption that, and has in its case law, a presumption that public officials will follow its precedent, will follow the rules, that presumption has been thoroughly rebutted by the experience of the last 5.5 years.
And then there are consequences for failing to do so, including, just like in the exclusionary rule, the dismissal of cases and professional liability consequences, correct?
For starters, Your Honor.
And aren't those loud and clear, or should be loud and clear to prosecutors?
Well, I suppose that might depend on the court's response to the whole lab argument that you just heard. But in addition, those consequences have the tendency to hold individuals responsible for what are in reality acts of institutions. Foster and Kaczmarek were trading at every moment on the Attorney General's credibility and authority. And so the reason why it's important in this case to impose these orders is that they will create this institutional incentive and responsibility for ensuring that these rules are followed. And this is actually something that the court has considered.
You don't think elected AGs and elected DAs don't have an interest in not having their assistants publicized and criticized and to be disciplined?
Well,
that's not a very popular thing for a DA to do, correct, and an AG to do.
Well, I can't speak to the interests of officials. What I can say is that the record before this court is at every moment a record of things that didn't work, that didn't actually produce the kind of behavior that you're positing will be produced, Your Honor. There were precedents in place. There were rules of criminal procedure and ethics rules in place. And yet, when this when this court heard the argument in December 2014, it did not have a letter from the Attorney General's office confessing error, nor, to my knowledge, did it ever receive one. So this is the clearest example of this kind of approach, Your Honors, actually goes back to the Manning case. In that case, the court said that it had contemplated imposing a per se rule. And again, it could be called a per se rule, it could be called a standing order, but it didn't go that step in that case, the court didn't, because the record before that court was not a record where the step that it actually took a Manning was proved to be inadequate. But yet that is the record before this court.
But what do you say, I mean, as far as the doctrine, because there were a lot of questions about what doctrine if we're going before June of 2012. So Manning is perhaps sui generis because it deals with a Sixth Amendment violation, and that obviously got the attention of the Supreme Judicial Court for good reason. And then you have cases that you would think perhaps there should be a prophylactic remedy. Commonwealth versus King comes to mind, and if not that, Commonwealth versus Lewin with the perjured affidavits. So what I'm getting at is there's clearly a reticence to have a prophylactic a remedy of dismissal because of separation of powers concerns, and just straight up, why should we not go follow post-Manning, and what about this takes us to what Manning, in your view, perhaps correctly, didn't quite finish?
Right. The reason why the court doesn't have to hold itself up on the post-Manning cases is that this is the most significant record of harm as a consequence of prosecutorial misconduct that the court has ever seen and that hopefully most courts would ever see. We're not talking about, in Manning, the sort of slight infringement on one person's attorney-client relationship. What we are talking about in this case is literally thousands of people suffering real, concrete harm. Some were sent back to prison. Some just had their prison stays extended. And some, like our clients Herschel Reeves and Nicole Westcott, were just made to suffer longer with the collateral consequences of their conviction. So although in Manning and some other cases the court has had to consider what is really the threshold of prejudice that the court needs to consider, here, as soon as the Foster and Kaczmarek began their fraudulent course of action, and as soon as the Attorney General's office decided not to tell this court about what they knew, they were extending the suffering of thousands of people. Now, there are different things that could be done. And so to the first argument, there's a question about how far does the initial taint of Farrick's misconduct go, and our submission to sort of in response to Justice Kafker's question is, Dukin and Farrick may have had different motivations, but it's like having a driver tell you, that they follow the traffic laws. One of them, Dukin, you know to be someone who wasn't trying to follow the traffic laws, and the second one may have been trying but was drunk, right? So that's the two difference, and the court has to wrestle with exactly how far the taint goes there. But here, in these other additional remedies, we really need to make sure that this doesn't happen again. And if this were any other law firm, if it was a law firm down the street that had an attorney that engaged in fraudulent misconduct that harmed thousands of people, and if that law firm then didn't act responsibly to mitigate the damage, that law firm would be bracing for some pretty serious penalties from a court.
What is it that you want us to do as far as the institutions go?
Well, the first thing is to adopt the standing orders as we've proposed, and perhaps to charge the Attorney General's office, which has reminded the court that it's the chief law enforcement entity, with making sure that those standing orders are followed. And the second, is our suggestion that there ought to be sanctions here in this case, because that's what would naturally happen in any case where it was a non-prosecuting office that engaged in the misconduct.
What's your view of the Attorney General's efforts post Judge Kerry's decision, I think in June of 2017?
Post-2017,
Post-June
there have definitely
2017.
been some steps in the right direction, but it's sort of like I think Winston Churchill has been said to have said, doing the right, so what happens when someone does the right thing after exhausting all the alternatives? So that's where we are. It's certainly welcome. We're glad that there's an assent to the standing orders.
I mean, I guess one of the things I'm referring to is the first assistant AG's affidavits about the intention internally to deal with these issues.
Well, there's really no way to slice that affidavit that would ultimately be helpful to the Attorney General's office. And the reason is that they're talking about steps that were taken in that office, even as they argued even as they declined to tell this court about the misconduct, and even as the Attorney General argued as late as 2017 to Judge Carey that there was no misconduct. The Attorney General's position until June 2017 was there was no misconduct that deserved any relief for any defendant by the Attorney General's office, and the Attorney General's office also took no position on whether Farrick's misconduct warranted relief. So it may well be that some of those policies are good, the trainings are good, et cetera, but no matter how good they are, the one thing we know about them is that they were not adequate to mitigate the damage of the very fraud in this case.
Can I ask you a procedural question? When we do rules, we generally have it reviewed by able judges and attorneys through committees, comes to us, to our Rules Committee, goes out for comment. If we were to do what you want, why would we not follow that procedure as opposed to declaring our own standing order and hoping that it's the right one?
Two responses to that, Your Honor, and I'll probably take the second part first. On the question of hoping that it's the right one, certainly whatever orders may come out of this process should have some flexibility built into them. This goes back to my response earlier to Justice Lowy. It's important that there be clear reminders, deadlines, and consequences, but they don't necessarily have to be set in stone. They can be adjusted. To the first part of your question, Your Honor, we're not going to object if the court decides to bring in other players into the process here. But unlike the normal process where standing order is considered, the goal here isn't to achieve unanimity or consensus. The goal here really ought to be to remedy the problem of misconduct in Massachusetts affecting thousands of cases and going unresolved. And that is that cuts in the direction of a different process than has been normally deployed. One other thing I would say about the importance of the nature of the orders. One of the most crucial features of the Bridgman Protocol was something that arose after this court's decision. It was a single justice order that says if the district attorneys fail to identify cases within the time period, there accrues a right to dismissal. So the part of my answer to your question, Your Honor, is that these things already exist in the context of this litigation, some of these procedures, and would merely be making them the reality in the Commonwealth. I see that my time is up.
Can I ask one more? What about the monetary sanction issue? I don't think you had time to get to that.
Yes, Your Honor. This goes back to the point about holding our institutions accountable, not to a lesser extent because they're the government entities, but at least to the same extent. That we have the chief law enforcement entity of the Commonwealth, an entity that had the authority, as soon as it learned about these cases, to require that that district attorneys move to dismiss them, and it didn't do that. So judging the Attorney General's office by the standards we would apply just to a law firm down the street, sanctions would be appropriate.
So I'm just trying to, so you want a monetary sanction against the Attorney General's office? Not individual Bivens-type damage remedies against particular offenders, but you want us to put an order in place that would sanction the AG's office?
Yes, Your Honor, and one reason why is that the other remedies that the court is being asked to consider dismissal, standing orders, they're primarily geared to the day-to-day functioning of the justice system and to the harm that the victims have suffered here. What
Can I just push you for 1 second? Because unlike a law firm, the public is going to end up paying. You and I and the rest of us are going to pay that sanction, right? It's going to come from an appropriation. It's not like a law firm where if you sanction them, the lawyers and the partners will pay. So I'm not sure are we punishing ourselves by sanctioning the AG's office? I'm not sure how that works.
Well, certainly the public fist could be considered in setting the amount, Your Honor, but the legal system every day has judgments that are imposed on public officials, government officials, where the public will ultimately be on the hook. But the theory, which we think is a good one, judging by the Attorney General's opposition to this particular relief, is that it will have a deterrent effect. And going back to your prior question, Justice Kafker, there is no other remedy in this case that has been ordered by this court that goes directly to the most serious misconduct, which was the chief law enforcement entity for the Commonwealth defrauding the Superior Court and, in effect, this court as well, and harming thousands of people. So the other response to your question, Your Honor, is that this is a case about real harm to real people. It's not just attorney time that was taken
almost every case we do is real harm to real people. It's just the magnitude of the number of people affected here is different. But I just
point taken, Your Honor. But I hope this is unique in the sense that the real harm to real people in this case was people being sent back to prison or having to stay more time in prison, and people having to suffer longer with collateral consequences because of what attorneys wrongfully did.
Do we have any sense of how many cases you're talking about between 2004 and 2012?
Your Honor, I don't think we know for sure. I think our best guess at this moment is probably that in total, if we add the 8,000 or so, a certain known ferric, I'm not sure if it's 8,000, but it's in the Attorney General's papers that it may be 8,000. If we add to that the whole lab, it may be somewhat less than the number of cases that were ultimately dismissed in the Hinton scandal, but we don't know for sure.
Your guesstimate was 19,000, right?
Guesstimate is the key word there, yes.
Going back to the issue of sanction, here's a real dilemma. If we impose a sanction which you say is commensurate with the extent of the harm, it's a very large sanction. If we do one which is purely symbolic, which is relatively small, are we viewed as understating the significance of the problem? So we have either a public fisc issue on one side, diminishing the ability of the AG to do everything else the AG does, and a slap on the wrist with a sanction that's symbolic but so small that it doesn't reflect the magnitude of the harm. What do we do with that dilemma?
It is a difficult dilemma, Your Honor. There are a couple of different responses. One is, one of the reasons why we have cited both remedial and prophylactic concerns as a reason for seeking sanctions is that we understand and our clients understand that there's really no way to issue an award that encompasses all the harms. So a sanction would be sufficient sort of qualitatively if it is sufficient to provide some measure of relief that could, for example, could be administered through this special master to the victims who have suffered, but also significant enough to have a deterrent effect, not just on the current Attorney General's office, but for all prosecutors in Massachusetts. And that would have to be a significant award, but it wouldn't be a matter necessarily of calculating harm and multiplying it by 8,000 or 19,000 necessarily.
All right, thank you.
Thank you, Your Honors.
Mr. Boshin, good morning.
Good morning. May it please the court. My name is Thomas Boshin. I represent the Attorney General in this appeal. So far this morning, we've heard a lot about the disagreements between the parties, but I'd like to start by pointing out a few of the areas where, there are actually quite a few, where the parties actually agree. First, we all agree that things went very, very seriously wrong here, and that broad remedies are needed to restore confidence in the criminal justice system. We also agree that thousands of convictions were affected by the misconduct that took place here, and that's why roughly 8,000 already have been dismissed. And we as an office also agree with the petitioners that additional remedial measures and institutional reforms need to take place to make sure that this does not happen again. As an office, we're committed to making sure that there's a criminal justice system that the public can trust. To that end, when the new administration took office, one of the first priorities it had was to target the behavior that set this whole extremely regrettable set of circumstances in motion, which was the withholding of the mental health records.
I'm confused, though. You're saying the additional measures are necessary, meaning the rules of ethics and the rules of professional responsibility and the rules of criminal procedure aren't enough. But if the AG's lawyers weren't complying with those, why are they going to be complying with these new orders? Aren't they all based on the integrity of the people complying with? If we're not adding anything of substance to the rules, I'm just not sure why people will comply with these new set of rules as opposed to the old ones.
I think
I mean, it's always, people break laws. That's why we're here. They don't comply with rules. We discipline them. Just because you add new ones, if they don't add anything of substance, I'm not sure how it makes sense. So let me understand why the AG supports this then.
I understand the court's point, but to take so we've agreed with the petitioners, for example, that misconduct should be reported promptly so that there can be oversight by a neutral judicial officer and it can be a transparent process. That is that the public can have confidence that a misconduct or that problems are being taken care of. For example, here, the affidavits that were submitted in the single justice session that are part of the record before this court show that the district attorneys and the attorney general were taking a number of steps, beginning at least in 2015, to identify defendants and move this process forward. Yet, because this was not under the supervision or oversight of a judicial officer, it wasn't a transparent process, and it perhaps is the case that the public wasn't as aware as they could have been of all of these steps that were being undertaken. So while I appreciate the court's point that people do break rules, what we're proposing is that these rules, or these measures, regardless how they're adopted, would create a system in which there would be more transparency and that we think the public would have more confidence in the process dealing with problems that occur and arise. And with respect to the standing Brady order, again, we agree with what the petitioners just said, which is that the important thing is that the procedures are made clear to the participants in the criminal justice system, and that there's prompt reporting. But with respect to the Brady obligation, we take the petitioner's point that even though prosecutors should all be aware of their obligations under Brady, there can be a beneficial effect to reminding prosecutors, and I think that's the reason why the New York court adopted the proposal that it had, but into reminding prosecutors before a case starts of those obligations. And that's.
But what do we, there were two issues in the AG's office. Judge Carey focused on one, which is the failure to reveal the mental health records, which would have opened up an inquiry into the duration and scope of Ms. Farrak's conduct. But there's a second issue, which is not really being addressed, I don't think was addressed in the briefs, which is that this court, not even knowing about the mental health records, looked at what happened in Cotto and in Ware and said, people are essentially closing their eyes to the scope of it, that the investigation is cursory, and essentially there is a, oh dear, this may be another Dukin, so let's make sure we only focus on what we see and don't really look any further because, golly, we may end up with another Dukin mess. So we basically directed or encouraged the AG to do it. But that's not, we shouldn't be in the position of having to be saying, don't close your eyes to the duration and scope of misconduct that may affect a whole lot of cases. And that's sort of what happened here. So how do we prevent that from happening? That's not a Brady issue, because even if you disclose everything you knew it doesn't deal with the lack of curiosity and the lack of an investigation to see how bad is this.
Well, I think with respect to at least the Attorney General's office and why it undertook the investigation after this court's directive or request in Cotto was because of experience in the Dukin litigation. And I'd refer to the court to exhibits 240 and 243 that describe how the Attorney General's office had, in the Dukin context, begun to undertake that investigation and had planned how it would be conducted and had spent certain amounts of resources to get that process going. And then just before it was executed, that is before the actual review took place, members of the defense bar raised concerns that the Attorney General's office could not conduct an unbiased investigation into both the lab and at the same time prosecute for, Dukin. So I think that having had that experience, we being the Attorney General's office, had made clear to other members of the government that our office was going to investigate the scope, the Farrak's misconduct that was before us, and that a broader inquiry into the lab should be done by.
But when you look at Dukin, in what happened, what the response was with the IG's report in the Meyer review, here what the petitioners say is we don't even know the scope as we sit here today of the misconduct. We don't know the cases. I mean, and obviously everybody's done what they can as far as tracing back all of at least the Farrak defendants. But as far as the scope of what she did, we're kind of relying on Ms. Farrak's testimony before a grand jury, and she's not the most reliable person in the world. So how do you compare what happened in Dukin with the IG's report in the Meyer review versus what happened here? And isn't this deficient?
I can't dispute the court's point that what happened in Dukin is different than what happened here. What I can speak to...
Well, the response was different.
That's right, that's what I meant to say. What I can speak to is the assertion that the Attorney General's investigation that was undertaken in response to Cotto was inadequate or somehow itself misconduct. We reject that suggestion. Judge Carey, found in his order, he commended what had been done in a reasonable period of time. This court's directive asked the Attorney General's office to begin promptly with an investigation and to conclude expeditiously, and the parties before Judge Carey also wanted or emphasized the need to proceed quickly to understand what had happened. So taking a step back, the Attorney General's office secured immunity for Farrak, took her testimony over several days, but it wasn't just her testimony. They also took the testimony of her 3 colleagues in the lab. There was testimony from Nancy Brooks, who conducted the October audit by the state police of the Amherst lab. They interviewed Annie Dukin, and there were thousands and thousands of records that were reviewed to include emails, records from the Amherst lab, financial statements. So given the limited time and resources, we think that the record amply supports Judge Carey's decision to commend what had been done in a reasonable period of time, and that investigation is certainly not a basis to find that the AG's office did something wrong, much less sanctionably wrong.
But that doesn't explain why it had to be us to tell you to do that. I mean, that's the fundamental issue.
Right.
We didn't even have the mental health records, and we saw that the investigation was cursory. You had them, including persons in the leadership of the Criminal Bureau knew of those records. But it was only when we said you better do it that you did it. And that's, I guess, that's the concern that can be repeated, which is there's an enormous inclination, I understand it, to say, oh dear, do we really want to walk into another Dukin mess? So we're going to put blinders on. We're not going to begin to question her with we're not going to conduct an investigation as to duration and scope. That's the problem that can recur, and that's not a Brady issue, because you can't, if you don't look, you're not going to find exculpatory evidence, and Brady does not impose an obligation to conduct further investigation to produce exculpatory information. But that's the concern which I'm concerned about.
And I understand the court's point. I mean, the best, or one response that I can give is to say that when the court looks at the record of the testimony of the people who were in the AG's office at the time, after this had come to light, the record shows concern, upset, confusion, frankly. How did this happen? And fortunately, this is not something that happens at the Attorney General's office often, so, or even at all, and we wouldn't expect it to. So in that moment, in that frame of mind. What they tried to do was to get these materials in the hands of people who could use them, the mental health records. And that is that they went out to the district attorney's offices who were prosecuting these cases, and within 14 days, and they also assented to motions to amend the protective order so the defendants could have access to it. It was a period of, like I said, confusion and upset. It just doesn't happen. And you know, in retrospect, you know, of course, we could have done things better. But in that moment, it just wasn't something, fortunately, that
And
we
I
had to deal with.
suppose this brings me back to the standing order issue, in that even if this court chooses not to go with that remedy or request, there's nothing preventing the Attorney General itself from implementing those procedures for its own office or recommending those to the district attorney, is there?
That's correct.
Let me ask you about your concession about 2012. And that's based upon Ms. Farrak's admission of tampering with some of her colleagues' samples, at least in June of 2012, correct?
That's right.
But you differ with the petitioners, and you say that now those defendants should come under a Bridgman protocol, Bridgman 2 protocol.
That's correct.
Hasn't the Bridgman ship sailed because of the misconduct? Why shouldn't there just be a straight dismissal?
I think that this court outlined in Bridgman competing interests that are involved in cases like this. There's obviously the interests of the defendants, but there's also society's interest in punishing crime, and there's what this court emphasized most strongly in Bridgman, the need for the interest in judicial administration and case-by-case adjudication. We feel that those interests here weigh in favor of a Bridgman-type solution instead of...
But when you read Bridgman and you read certainly Justice Hines' concurrence, as well as I think Justice Links, they said, if not now, when, right? So there is some discussion by this court of this is really bad, but you're lucky there's no prosecutorial misconduct. Now we've got it.
That's true, but the court also said in Bridgman that the reason to resort to that, as it said, drastic remedy of last resort was to create an environment in favor of deterrence that would not otherwise exist. Here we think that there are several deterrents in place to make sure that this does not happen again, and that remedial measures, whether they're adopted as part of a rulemaking process or as standing orders, can add layers of protection for the defendants. I mean, obviously, Farrak went to jail. The 2 assistant attorneys general were reported to the Board of Bar Overseers. Judge Carey wrote a very strongly worded opinion referring to them by name. They've been the subject of national media attention. It's been very, very negative. I mean, there are a lot of deterrents in place that would have to think that no one would in this environment think that this is something that was okay or that should happen.
Why shouldn't the Bridgman 2 defendants go earlier than June of 2012? It seems that a lot of the June 2012 depends on Ms. Farrak, who, putting aside why she might want to minimize, would have questions about her testimonial memory. We're depending on the observations of the other members of the lab, and why shouldn't the Commonwealth have to come forward and say, as it relates to these cases before June of 2012, that we certify that we can go forward here and ethically prosecute these cases?
Well, we have this record, and we looked at this record, and we thought that there was an evidence-based reason to be concerned about the convictions that we've identified. It was Farrak's testimony, true, at the
And
hearing.
also, tell me if I'm wrong, it's a huge record, but I think the 3 of the examples that she gave of using other chemist samples, that those cases didn't even exist.
We were never able to find those samples, that's right.
So
But
that raises concerns about somehow the magic date here is June of 2012, and all the eggs are in Ms. Farrak's credibility basket. That's a little bit of a concern.
Well, Judge Carey found that the summer of 2012 was when she started to, or she testified that that's when he found that she testified that's when she started to use or take from other chemists samples. There was her proffer. There was joint proposed factual finding that was signed by the district attorneys and the petitioners, the defendants in Cotto 226, which said that Farag testified that she began using other samples. There was the corroboration of the corroborative testimony of others regarding her behaviors and her appearance. So on this record, we looked and tried to be as inclusive as possible. The summer was the earliest date by which there was evidence that she had tampered, and thought that on this record, those individuals should be entitled to the Bridgman relief. I see that my time is up. May I say just a few words about
I'm
sanctions?
just confused, though, by that, because we know she's heavily using from 2004 to 2012, right? And she's saying she's getting all her drugs from the lab, right? So I just don't understand why that doesn't prejudice the 2004 to 2012 period completely. And also, there are no controls in this lab. And there's also not two chemists analyzing things. There's just one. So doesn't that make this a mess that we can't unravel? I'm just trying to understand how we would do that in a principled way.
Well, for the samples that she herself tested, the relevant Farag defendants have been
that's easy.
dismissed.
Her samples are easy.
Right.
It's everyone else's and what we're going to do in that earlier period. I mean, I'm sympathetic that the AG's misconduct, I'm just not sure the causal connection to it going backwards, I have trouble sorting through, but I worry that we have a heavy drug user digging into all the drugs, no controls in place, and I wouldn't believe a word she says at this point. So I'm just trying to understand how the AG is comfortable, because you're lashing yourself on certain things, but on other things you're not. So I'm just confused by that a bit.
Well, again, we looked at what's available in this record, and if it had been just her testimony alone, that might be different. But here, there were observations of others that Judge Carey took the testimony of. He watched them testify and credited that corroborated a deterioration in her condition or an increase in the effect of her addiction on her functioning in the latter half of 2000.
But that takes a while to build up, and to reach a level where it's noticeable to a third person would suggest that it's been going on for a while before it becomes noticeable, doesn't it?
It could.
It has
On the
to,
evidence,
it
I mean,
ramps up.
I can't dispute that, but the record here was that she began in the summer of 2012. That's what we were trying to work from, was the record.
Because she had full access to all the drugs at every time, do you have any confidence about the chain of custody of any sample in that lab from 2004 to 2013?
Well, Justice Carey, I'm sorry, I keep saying Justice. Judge Carey heard testimony about the lab, and he found that there was no reason to question the reliability of samples tested by other chemists besides.
That's a different question than what Justice Gaziano asked.
Do you have any confidence in the chain of custody?
On the record, there's no basis for me to question the chain of custody. Again, we just looked at this record and tried to take a position that was in the interest of justice with respect to the defendants who on this record seem to be deserving of relief. Would the court permit me just to say a few words about the sanctions issue?
Just before you finish up, does the AG's office believe that there should be some sort of punitive consequences at all for the actions of its assistants?
And that's where I wanted to go next. Where we disagree or differ from the petitioners is on this issue of monetary fines. We think that would be unprecedented. We haven't found a case where this court has done something like that in a similar context. I haven't seen one that the petitioners have cited. And more importantly, there's no finding here. One of the factors that this court looks at often is institutional bad faith or bad faith. There's no finding of institutional bad faith here. In fact, Judge Carey, to the contrary, found that the remaining people in the Attorney General's office were, quote, committed and principled public servants. And another fact that the court has looked at is it necessary to issue monetary sanctions? Is it necessary to create an atmosphere of deterrence? And here, for the reasons that I mentioned earlier, would say that it's not necessary. There are other deterrents that are in place that can help make sure that what happened here does not happen again.
But the AG itself imposes fines say for violations of the open meeting law against cities and towns. So you have sought penalties against public entities where the taxpayer will be bearing the cost. What's the difference between your going after a town for an open meeting violation versus our sanctioning the AG for its failure here?
I think in this court's sanctions cases, this would be unprecedented, but in sanction cases that do exist, there has been some finding of institutional bad faith, or there's been some finding of institutional misbehavior over time, and that is just, neither of those is supported by this record. And in fact, to the contrary, Judge Carey's finding was that the remaining individuals in the Attorney General's office were committed and principal public servants.
All right, thank you.
Thank you very much.
Mr. Pirapan. Good morning.
Good morning, Chief Justice Gantz, members of the court. Let me first, my name is Joseph Pirapan for the district attorneys. With me at council table is ADA Suzanne O'Neill from the Norfolk District Attorney's Office, and she largely spearheaded the district attorney's response to this petition. If the court wishes, with the court's permission, let me say, I wish to address first the issue of the reliability of the Amherst lab in general, and particularly those of the chemists, not Ms. Farrak. I think it's very important for the court to understand that in addition to the Attorney General's investigation, in addition to Judge Carey's investigation, for lack of a better term, the parties themselves offered a stipulated facts, over 500, I believe, in which the petitioners and certainly the DAs sat down for weeks and actually hammered out an agreed set of facts that Judge Carey incorporated into his findings. The district attorneys were hopeful that Judge Carey would then move immediately to a stage 2 Scott hearing with regard to the consolidated cases in Springfield. He did not. Instead, he summoned numerous witnesses, many of whom had already testified in the Attorney General's investigation. The parties, the petitioners, and the DAs and the AG had the opportunity to present not only live testimony, but these witnesses were subjected to cross-examination based upon their prior statements, whether they were consistent or not. And as a result of that, after a very deliberative period of time, I think it took Judge Carey 6 months, or 5 months, he then issued a set of findings that the district attorneys would encourage this court to defer to for terms of factual findings. Now, more specifically to the point, what evidence do we have that there's anything beyond 2012, let's say, to cause, to question the petitioner's suggestion of doing a Bridgman-type protocol, or even, the AG's position to do a Bridgman protocol, or in fact to have all the cases dismissed? There has been no finding, notwithstanding the fact that it was known that Sonia Farrak, from the day she started that lab, was addicted to narcotics, that from the day she started that lab would use narcotics illicitly obtained from outside the lab. She then eventually started using drug lab standards, not samples.
We don't know event, but we don't know any. We know she's an addict. We know she's got unlimited access to drugs in the lab. We really don't know. And we know the 3 other people in the lab are conscientious public servants, and they're not doctoring samples, but we don't know what she did to their samples, right? We're guessing at this point whether she's telling us the truth about pre-2012, aren't we? She's an addict, and she's consuming an enormous amount of drugs every day, based on what I read in those findings.
Fair statement, Justice Kafka. Let me remind the court that I don't think Judge Carey accepted Sonia Farrak's testimony either. He critically viewed her testimony. But more importantly, what facts do we have that there's any tampering that caused prejudice to a defendant? If through,
See, that's the only thing I can think of.
let me
is
answer the
that-
question, please.
Yeah, go ahead.
If we look at the affidavits from the district attorneys, including one from myself, there has been no reports in any DA's office of any drug samples coming back with the wrong pills in them or a miscounted number of pills until 2012. Those are the only times we see, and I understand that that's not a universal search of all the records, I understand that.
And
But
she's
up
not
until
even- but she's-
2012.
but she's not focused on pills, right? Her drugs of choice are cocaine, crack cocaine, powdered cocaine.
Primarily.
And some other things. I'm not sure if they're in pill form or not. I'm not.
But more importantly, Your Honor, there were instances where even the weights were questioned when the analysis came back from the laboratory, and the line prosecutors and the police said, hey, we gave you A, and we're getting back B.
So from 2004 to 2012, we don't have weight differentials?
None, only based upon the affidavits that I have, none that were discerned by the DA's offices.
Is it possible that she had access to the standards too at that point?
She admitted
correct?
using the
And
standards.
she used the standards, but is there any evidence or any indication that she supplemented those standards with additional material so that perhaps the standards were diluted so that when they were tested, they may look like they matched,
I
but they
don't believe so, because in fact, the evidence was the standards were disappearing quickly.
disappearing?
And which indicates that, at least in parts, in terms of the comparison, there was less fear or less risk that the standards were being compromised. As part of Judge Carey's investigation, hearing, I should say, there was extensive testimony about whether or not the lab's use of the standards. There's a question whether or not even homemade standards were appropriate. And that was fleshed out in addition to the possibility of tampering with standards.
Go ahead.
I think the petitioner's response in part to that argument would be, well, as soon as Ms. Farrak was arrested and the car was searched, January 2013, if that information had been turned over, then the search might have turned something up. But now, in 2018, to put the burden on the defendants, when the reason for the delay was not any fault of the defendants, puts them in a very difficult position of being able to demonstrate prejudice, and that we should have Commonwealth versus Manning type of presumed prejudice. So I think they would say, okay, well, if we had it in 2013, that's a reasonable argument, but not now, if we have to defend these cases now. What's the response to that?
Let me ask Justice Lowy specifically, is the court suggesting that in 2013, all the drug samples could have been retested?
I have no idea.
I don't understand the scope of your question. I understand that an investigation would have been more timely in 2013, but drug samples from 2004, 5, 6, 7, 8, 9, 10 still exist. They could be retested. I would say that in all probability the answer is no. State police were destroying and DPAs were destroying drug samples commonly.
So then where does that leave us, though? If one, she's very intelligent, this person. We know that sometimes she rejiggers the packages to get the weights back to where they were before, right? We know there are no controls. You're saying we can't retest them. Unlike in Dukem, we don't have two chemists. I'm just trying to understand what you're going to accomplish with a Bridgman 2 protocol.
I'm not advocating a Bridgman 2 protocol.
So, excuse me?
I'm not advocating a Bridgman 2
So
protocol.
what are you advocating?
I'm advocating that the Farrak defendants be defined as those defendants whose certificates, and only those defendants whose certificates were signed by Sonia Farrak, have their cases dismissed with prejudice. And the district attorneys, in their discretion, have agreed to do that. That sanction has already been
That seems
wrought.
easy, though. I'm just trying to figure out anything beyond that is
Well,
where it gets hard.
First, Your Honor, with all due respect, it wasn't that easy.
Well,
It's easy in hindsight to say egregious government
I
misconduct.
think they agree with you, too.
And I think, but a lot of effort went into that, Your Honor.
I don't mean easy in terms of lack of work. I mean that
Thank
where
you.
we are now.
Thank you.
I think that it's really difficult to rely on a Farag certificate.
Mr. Perrapin, I think, let's go back 4 questions, I think, to Justice Kafka. You were telling us why the other chemists' tests were reliable. You got as far as, look at my affidavit and the affidavit of the ADAs. What are the other reasons why you contend the other chemist tests are reliable and they shouldn't be dismissed or subject to abridgment protocol?
Well, Judge Carey, in his hearing, credited the internal audit conducted by the state police. He examined personally Rebecca Pontus, Sharon Salem, James Hanchett, and they answered very tough questions. And the aspects of the Amherst lab were sort of a two-edged sword. Because it did have some dysfunction in it, and deficiencies rather, related to the opportunity for other chemists to obtain access to other materials. It was also a very, it's only 4 people in that lab. And as the employees pointed out, even they noticed that wasn't until the last few months of 2012 that they visually observed Ms. Farag being sloppy in her workstation, sloppy in her appearance. Keep in mind that when the state police searched Ms. Farag's workstation and the rest of the lab, it's only then that they found laid out in the open these K-packs and these other obvious indications that she was interfering with other chemists' work. But Judge Carey found, even notwithstanding that, the other chemists' analysis, at least in terms of drugs, no drugs, was reliable. With regards to the question of weight, Justice Kafka, I mean, clearly a concern. I suggest that Sonia Farag was turning wine into water. She was replacing what she thought was similar amounts of product with counterfeit or other materials, which I understand could perhaps jeopardize weight.
So is that the principle you want us to act on, that because she's only stealing drugs for use, she's not doing what Dukem is, which is, ingratiating herself with the prosecution by
Falsifying
producing-
information.
Falsifying things. We therefore can say that there are not going to be any false positives out there. The weight may be wrong because we don't have any confidence that she's not filling the weight.
2 points. I agree. She unlike Ms. Dukin, who was motivated by the quest to become super chemist and analyze more samples than is humanly possible, which then caused us to question anything she touched. Similarly, with Farag, we have questions about her reliability because of the nature of her addiction,
Right.
and more importantly, because of the fact that she now is under the influence while testing. But nonetheless, she was never motivated to turn negatives into positives or to simply ignore evidence and classify it as positive so she can move on to the next one. If anything in her testimony rang true is the fact that she only wanted the good stuff. Mm-hmm. And so I think, I don't mean to be flip about it, but that's probably the most truthful statement she ever made.
Can you expand on the state police audit? My memory is they came in and they said the procedures that are used by this lab, even though they only have one chemist, even though they do the, I guess, the homemade samples, that they produce reliable results. But did the state police audit drill down into past testing and look at weights and look at kind of the number crunching that we would expect would happen in a case like this?
I can't give you a specific answer, Justice Gaziano, because the record is quite large. But what I can say is that once state police took over the lab, they recognized, and that was in 2012, I believe, from DPH, they recognized that there were some shortcomings. In fact, even prior to the state police taking over the lab, there was an acknowledgement that the Amherst lab, possibly Hinton, well, no, actually, I think it was just Amherst, didn't conform to national standards. This was all known at the time these audits were done, at the time these investigations were done. And so I apologize for not having a specific answer, but what I can say is that throughout the 6 days of hearings in Springfield, It was, Judge Carey left very few stones unturned.
It's a little awkward, I guess, maybe even a little disconcerting, but the Commonwealth has two different positions here. The AG's position is Bridgman 2 from June of 2012 till January 2013. The DA's position is no Bridgman 2, and the AG's position is that protocols are a good idea. The DA's position is that it isn't. So when we talk about this case, we've got two different positions of the Commonwealth. Any guidance for us as we start to work through that?
Absolutely, Your Honor.
Would you share it?
Absolutely, Your Honor.
Would you mind sharing it?
I was hoping you'd ask that question. First of all, the Attorney General's brief and the efforts that they've taken to acknowledge responsibility and to implement measures forward are laudable. Second of all, rules are only as good as the people that you hire to obey them. And the sad truth of the matter is, and I think it was pointed out before, perhaps by Justice Gantz and others, that notwithstanding the fact that the police and the AG had these documents in its possession, for whatever reason, the people who were in possession of those documents did not either comprehend the relevance of them, or if they did not share the significance of them. And any rule that's in place, it wouldn't, I suspect, would not have cured that problem. Notwithstanding that, the district attorneys would strongly suggest that rather than have a standing order with arbitrary dates and timetables, that this issue of systemic misconduct, if it were to arise again, be subjected to review by the Rules Committee for perhaps implementation within either Rule 14 or even another rule, whereas we can have a means to facilitate the protocols that this court has already handed down in Cato and Bridgman. I think we know what the outcome could be, would be, should be. The problem is getting there. And as we saw in Bridgman 1 and 2, despite the best efforts of all parties, it took time. In the instant case, despite the best efforts of the district attorneys as early as 2013 to identify, in many cases by hand, the Farrak defendants, and to segregate those files and to review those files, and to present a list to the court in a timely fashion, these procedures take time, which would, I think, be best facilitated by a rule which would encourage the trial court to become involved immediately and initially with sharing information, to facilitate the dismissal of cases before a suit has to be filed. The district attorneys do not agree with the petitioners that they did nothing until the suit was filed. The affidavit speaks to the contrary. There are efforts being made well before 2017 to identify these defendants. There are efforts being made to notify these defendants that were met with opposition.
Now, let me ask you a different kind of question before you follow up on that, and that is, if there were to be found evidence of systemic misconduct, say it's under a rule change or whether it's under a standing order, why not reverse the order or reverse the burden and say everybody is presumed to be tainted until the district attorney's office can prove the case is not tainted?
The question I have with that, Justice Seifer, is who is everybody? You know, I understand that in the world of the Amherst lab, where we have 4 chemists and 20,000 samples, it sounds manageable. I'm here to suggest otherwise, that the evidence that's produced through the course of years of investigation, culminating in Judge Carey's hearing, show there is, in fact, no firm evidence to prove that any samples other than Ms. Farrak's were unreliably tested and reported. I think that what the rule, a future rule or an amendment rule should contemplate is, first of all, rather than arguing about who's liable for what, get this matter in front of the court as soon as possible. So, because things work much better when a court, a judge say, show up tomorrow and let's get to work on this.
Could I ask, in your response to Justice Gaziano's, you may have already said it, chain of custody, what's going to be the response to the chain of custody point?
Well, here again, Your Honor, the chain of custody, I think, is any questions of the reliability of chain of custody are similarly not affected by the findings of Judge Curie. Even if Ms. Farrak had tampered with she acknowledged in her own testimony that when Springfield came in with a heavy drug bust, she would dip into the sample before it was heat sealed, or even after it was heat sealed in a minor ways so as to permit her to interfere with it. The point I'm trying to make is that those drugs eventually went through either Ms. Farrak or another analyst back to a police officer, to a line prosecutor, and it would appear that the drugs that went out were the drugs that came back. And I think that this is probably the best way of showing that where the prosecutors recognized and the police recognized that they weren't getting back what they submitted, that's the internal control that we can rely upon. And the DA's office has brought those matters to the defense's attention, as we've seen in our affidavit. And I think that chain of custody is a matter of weight, not admissibility. Great weight, I get it, great weight, but nonetheless, I think there are enough
I guess
standards.
I guess a better question than chain of custody is confidence in the integrity of the sample, because if go back a bunch of years, you're a line prosecutor, right? Mm-hmm. And you've got a case that a county has brought in, and you learn that when the police department submitted it, the chemist fake heat sealed it, sampled it, then heat sealed it and sent it out. As a line prosecutor, wouldn't that give you a problem? Wouldn't you think that was a Brady violation? Wouldn't you have an issue with the integrity of that sample?
Okay, 3 questions there. Number 1, is it a Brady violation? Is it Brady evidence? Absolutely. Number 2, do we have an obligation to reveal it? Absolutely. Number 3, does that mean that the evidence is per se improper, inadmissible? If you get 100 bags of cocaine, the random sample 2 or 3. So I would say, because that's the standard of sampling, that it should not affect the overall analysis. What I'm concerned about, Your Honor, is when we send out 5 bags of cocaine and we get back 15, or we send out 25 bags of cocaine and we get back 1. Then we know that something's wrong. And there are those obvious circumstances when that happens. We will note that Ms. Farrak said that when Springfield came in with 100 grams or a kilo of cocaine, it's good stuff, and she only took a small percentage of it. Arguably, the balance of the sample is not compromised.
I think the petitioner's point is take Justice Gaziano's example and add to it, and the DA tells the defendant 5 years later. That's the concern.
You're sprinkling prosecutorial misconduct to the hypothetical.
Well, but here again, getting back to whether or not any of the non-Farrak samples were affected by the Attorney General's misconduct, I would say the answer is no.
Let me ask you one question that goes to your example. Let's assume the DA or a DA discovers what you just described. You agree? You have an obligation to disclose that to defense counsel in that particular case. Any obligation to determine the scope and duration of what may be substantial misconduct by that forensics examiner?
Well, certainly in regards to a state laboratory, the word should go up to an immediate supervisor.
But it didn't here, and that's, I mean, I understand what a nightmare this has been, and I understand how many thousands of hours the DAs or the defense lawyers have had to devote to addressing this issue. So I know it's a nightmare, and I know that there's a reluctance to open up a nightmare by trying to find out just how bad this problem is. But I think we all agree that that needs to happen, and the question is, how can we make sure that it happens next time?
And Your Honor, I hate to be the bearer of bad news here, If somebody doesn't want to reveal information and keep it a secret, they can keep it a secret. Unless we put cameras in everybody's desks and everybody's lapel.
I'm not referring to secrets, I'm referring to things, I'm referring to,
Deliberate
the equivalent
misconduct?
of the Watergate burglary, that we have some indication that something is very wrong, for the reasons you just described.
I understand.
ADA is looking at something and saying, this is, something is screwy is going on in the lab.
But the problem that we are dealing with is, we have an example of prosecutorial misconduct in which any rule, I would suggest, would not have cured that or prevented that. If in fact there was a deliberate delay of 5 years to reveal exculpatory information, I think number one, those, full investigation and disbarment. The BBO should be the final arbiter of misconduct. I think those are the tools that we have, and to the extent that we deal with human behavior and human conduct, all institutions are under suspicion at this time, whether it be courts, police departments, DA's offices, or otherwise. We're all humans. We can only hope that the rules that we implement are followed and that we have procedures in place that will punish known violations of those rules.
But I guess that's certainly the failure to hand over exculpatory evidence is right now a violation of all kinds of rules. Should we impose a rule that requires some degree of due diligence, where there is indication of what might be widespread misconduct during the course of an investigation, whether it be by a police officer who could be planting evidence, or a lab technician who could be messing with samples?
I think through the remedy lies in amending the existing rules to allow for a tailored approach, as we saw in this particular case here, to uncover eventually the entirety of the problem. And I understand that it may result in more time spent, and that will cause prejudice to individuals. But I think that a one-size-fits-all approach is not appropriate. I think until we determine what the scope of the problem is, as we saw demonstrated in the Farrar case, we don't know what we have to deal with. We need to establish protocols to get to the scope quicker. And I don't think by imposing 90-day rules and 60-day rules and 30-day rules, that's going to solve the problem. I think we can get all the parties together, and resolve things more locally, as opposed to waiting for a Commonwealth-wide lawsuit. That would be appropriate. But when we have blowback or pushback from counsel in the courts and an inadequate database, these are real-life problems that we have to deal with, which merits tailored responses to these egregious acts of misconduct. I'm not denying they exist. I don't want them to exist. And the DAs do not shirk from any nightmare. We do not shirk from any nightmare. It is, I think, to claim that if a prosecutor were to hide evidence for 5 years, that would result in an indictment. And I suspect, too, that those days could be coming as well. But in terms of can we ever prevent deliberate, intentional misconduct, I think not. We can only best find ways to prevent the negligent or the incompetent lawyering, which is more of a problem, I think.
All right, thank you, and we'll take our morning break.
All right.